Hello everyone. Today I'll be telling you about a very important doctrine of Indian Constitution, and that is the doctrine of waiver. This doctrine has been formulated in view of the provisions enshrined in Article 13 of the Constitution, which talks about the supremacy of the Constitution. So here the word waiver means to quit or to abandon, means छोड़ देना, जाने देना या त्याग देना. So this doctrine is about waiving our rights that we have got being the citizen of the country, or the right that we have got as human beings. So this doctrine is based upon the principle that a person is his best judge and he has the liberty to waive the enjoyment of such rights as are conferred on him by the state. मीन्स हर इंसान अपना बेस्ट जज है और अगर वो चाहे तो अपने राइट्स को रिलिंक्विश कर सकता है या छोड़ सकता है विदाउट आस्किंग फॉर एनीवन्स परमिशन. बट देयर आर टू कंडीशंस फॉर दैट. फर्स्ट वन, that the person should have the knowledge of his rights, and the second is that the waiver should be of voluntary. Means the doctrine of waiver in the Indian Constitution involves the voluntary relinquishment of a legal right. In simple terms, it's when someone chooses not to exercise a particular right granted by the Constitution. For example, imagine a person has the right to remain silent during police questioning, which is a constitutional right, but if that person willingly decides to speak and provides information, they are essentially waiving their rights to remain silent. So basically, this doctrine emphasizes the voluntary nature of giving up constitutional rights. No one can force you to do so. You have the power to enjoy your rights or to waive it. But there is a point to note that once you waive your rights, you cannot claim it again. एक बार आपने अपनी मर्जी से अपने राइट्स को वेव कर दिया तो आप फिर से क्लेम नहीं कर सकते उस राइट के ऊपर. Now here the question is that whether such right of waiver extends to fundamental rights also, means whether a person has a choice to waive his fundamental rights or not. So the answer is no, since the fundamental rights are not absolute and are subject to certain reasonable restrictions. Therefore, an individual cannot waive his fundamental rights. So in conclusion, the doctrine of waiver is not applicable to fundamental rights. Now let's cast a look upon a case law where Supreme Court has applied the doctrine of waiver. बसेश्वर नाथ वर्सेस इनकम टैक्स कमिश्नर के केस में अपीलेंट बसेश्वर नाथ ने इनकम टैक्स डिपार्टमेंट को 3 लाख रुपीस पर मंथ पे करने के लिए अग्री किया था अंडर सेक्शन 5 सबसेक्शन 1 Taxation of Income Act. However, the act was eventually found to be unconstitutional. So the appellant filed a lawsuit against the agreement. But Income Tax Department ने ये claim किया कि by agreeing in a settlement, he had waived his fundamental right. So the Supreme Court held that since Section 5 subsection 1 of the Act was ultra vires of Article 14 of the Constitution, so the Supreme Court rejected the contention of Income Tax Department and held that fundamental rights could not be waived. I hope this video has helped you to understand the concept of doctrine of waiver. This is it for today. Thank you for watching.